Welcome, everyone. Thank you so much for joining us today for this Korea webinar, jointly hosted by SIAC, the In-House Counsel Forum, and Yoon and Yang. My name is Michelle Sonnen. I am the head of Northeast Asia at SIAC, and I will be your MC and moderator today. We are all delighted to be here, and thank you so much for joining us. Today's webinar is on the emerging regulatory and disputes landscape in the areas of ESG and new technologies. We have an exciting program for you where we'll be discussing areas of risk and also the kinds of disputes that we have seen thus far in the areas of ESG and technology. We are fortunate today to have a diverse panel of speakers, including ESG and dispute resolution specialists based in Korea, Singapore, Japan, and Malaysia. Joining us today are Ms. Sharon Chong, member of the YSIAC committee and partner at SCRINE in Kuala Lumpur, Dr. Joseph Chun, partner at Shook Lin & Bok in Singapore, Ms. Myung-An Kim, co-head of the International Arbitration Team and senior foreign attorney at Yoon and Yang in Seoul, and Mr. Joaquin Jack Terceno, partner at Freshfields, Brockhaus & Derringer in Tokyo. Thank you all for being here today to share your expertise with all of us and with all the attendees. So let's go ahead and get started. As we go along, should you have any questions, please type them into the Q&A box at the bottom of your screens. We'll address them as we go along or at the end if we're not able to get to them throughout the duration of the webinar. Okay, so ESG has really become a buzzword in the international legal community. And we know that many in-house counsel have questions about what developments in ESG regulation will mean for their companies. Joseph, can you start us off by giving us an overview of the regulatory environment for ESG?
Right, thanks, Michelle. Very pleased to be here to share my thoughts on ESG today. So in Singapore, in the last few years, there's been a lot of regulatory activity, starting with the SGX listing requirement that listed issuers now have to, from 2017, on a comply and explain basis, issue annual sustainability reports. This basically requires listed companies to identify the material ESG factors that may affect the company in terms of its continuity, and then to look at the policies, practices, and the performance of the company in relation to these ESG factors, and then to propose targets that they would like to be their performance to be measured by, and then the directors are supposed to then make a statement to say, we have considered the impact of ESG on the company, and we have sort of incorporated these risks into our strategies accordingly. So this is the first regulatory introduction in the last few years. And the Monetary Authority of Singapore has also since last year issued guidelines on environmental risk management for financial institutions. These are the banks, asset managers, and insurance companies in Singapore. They are now expected by June 2022 to have in place governance systems and strategies for identifying, sort of assessing and managing environmental risks. These can be physical risks, can be transition risks, can be reputational risks arising from changes in the environment. And then lastly, they are expected to disclose their systems and management processes in a sort of internationally recognized format, preferably the TCFD, the Task Force on Climate-Related Financial Disclosure format, so that sort of all investors as well as the central banker is aware of the systems they have in place to address this sort of risk. Also particularly sort of relevant is that banks, financial institutions are expected to develop expertise in scenario analysis to understand the short, medium, and long-term environmental risks and how these impact the financial institutions' operations. They're also expected to engage with the investees, engage with the borrowers to try and reduce the exposure to environmental risk. So this entails duties of stewardship to make sure that the companies they invest in understand their own environmental risks. And then going forward, there'll also be expectation that from next year, ESG retail funds will have to disclose their selection criteria for investment, the ESG strategies that they are using, the risk and limitations involved, and also give updates on whether ESG objectives have been met. And quickly, going forward, I think there have been sort of a significant development. This is the development towards green taxonomy. Singapore, as well as ASEAN, have been busy developing a green taxonomy. This helps to determine what's green and what's not. Long story short, it very much follows on the EU sort of taxonomy kind of model, but Singapore and ASEAN have both recognized that while the metrics can follow those of the EU, the thresholds, what constitutes green and not so green, will have to take into consideration the situation in Singapore as well as in ASEAN. So the thresholds may be different, but the metrics certainly they are going to look very much to follow the EU sort of measurements. This is to ensure interoperability between sort of taxonomies. So I'll stop here.
Okay, great. Thanks, Joseph. That's great. Maybe I could get Sharon to come in and also offer some perspectives from Malaysia.
Thanks, Michelle. Thank you for having me today. That was a very excellent overview of the ESG regulatory environment by Joseph. I just want to add a few points from a Malaysian perspective. The main regulators in Malaysia, the Securities Commission, the Stock Exchange Bursa, as well as the Central Bank, similarly require listed issuers and financial institutions to specifically take into account sustainability and ESG issues. Listed issuers and financial institutions are required to issue a sustainability statement in respect of their management of economic, environmental, social risk and opportunities, including their governance structure in their annual report. In April this year, our central bank published Malaysia's national climate focus sustainability taxonomy for the financial sector, which is called the Climate Change and Principle-Based Taxonomy, which sets out 5 guiding principles intended to help financial institutions assess and categorize economic activities. And essentially, they're encouraged to apply the guiding principles in the transaction duty processes to assess whether economic activities fall within one of the 3 sustainability categories, which are 1, climate supporting activities which with a positive impact on climate change mitigation or adaptation and no significant harm to the environment. 2, transitioning activities which with a potential harm to the environment, but remedial measures taken to reduce harmful practices. And the 3rd is watch list, the activities with a potential harm to the environment and with no remedial measures taken to reduce harmful practices. So essentially, these obligations are all part of the fiduciary duties of the board of directors, where directors are required to act in the best interest of the company. And the board has to, is required to make the right decisions so that the companies can be future-proof against risk of climate change, of social issues, as well as corporate governance issues, essentially the ESG issues.
Mm-hmm, mm-hmm. Thanks. I think that something was mentioned with harmonization, and I know Singapore is looking at the EU standards. Just looking at Singapore and Malaysia, do you see a harmonization of standards there at this point? Is that something that's being worked toward? Either Joseph or Sharon, just feel free to answer that.
So I'll take a step first. As Sharon has pointed out, the Malaysian taxonomy is kind of principle-based, and Singapore is kind of headed towards a threshold-based. So with kind of quantitative and maybe in some cases qualitative thresholds, what kind of performance standards will be green and what will not be green. The Malaysian one is kind of principles-based. The ASEAN one, which is meant to be an overlay over all the ASEAN member states, actually has both the principle-based and the threshold-based. I think ASEAN intends that there will be this flexibility where you can assess the greenness of an activity either based on the principle kind of approach, non-threshold, or you can use the threshold one. And over time, it looks like they are going to sort of encourage all the member states to go towards the threshold one because that has greater precision and it's aligned with the EU system. But for a start, because many of the ASEAN member states don't have the kind of data, and also it takes a long time to get the thresholds out that everyone can agree on. I think for a start, they are going to allow ASEAN member states the flexibility to either use a principle or a threshold kind of approach. But yeah. eventually we'll all get there, and be on the same page.
Sure. Thank you for that. Yeah, I'm sure companies appreciate having some flexibility, particularly in an emerging area like ESG. Okay, well, let's then dive in a little bit deeper and look specifically at the E in ESG, environment. So Joseph, I know environmental issues is one of your specialty areas. So can you tell us what are the potential risks arising out of the environmental regulation specifically?
So one of the major risks I see happening now is that with everybody sort of trying to outdo each other with green commitments and pledges, there is this concern of greenwashing. And greenwashing simply means making statements which cannot be substantiated or basically which not reflect the actual sort of situation or the practice of the company making that commitment or pledge. And greenwashing can lead to legal liability. In Singapore, it is an offence to make a false or misleading statement, which is in a material particular that induces others to subscribe for security, and that is made with actual or constructive knowledge that the information is false or misleading. There's also statutory civil liability if it leads to loss of by an investor relying on the false or misleading statement. We also have consumer protection laws that make it there's an administrative liability incurred if there is if a company engages in an unfair practice, which includes failing to or omitting to give information that a consumer may consider relevant in his purchasing decision. So then lastly, we have a Singapore Code of Advertising Practice, which sets out kind of guidelines on things like you must be able to substantiate your claim, don't make overly broad unsubstantiated claims, don't claim something to be of universal scientific acceptability when it's not true, make sure claims are relevant, don't say something is carbon neutral when that product has no carbon emissions to begin with, so that kind of claim is irrelevant and misleading. And so on. So there are many sort of levels of liability to look out for. In Singapore, we haven't had a case where someone has been taken to court or legally challenged for greenwashing, but we had a recent case where a supplier of cooking gas, by the canister, advertised on his Facebook post that healthier families cooking with healthier gas. Okay. And somebody made a comment on the Facebook post and said this is greenwashing because gas is not clean because it contributes to climate change. And the advertiser or the company actually took down the post. Okay. And then it got picked up in the environmental media. So this leads to reputational risk, even if it doesn't lead to a legal sort of liability. So I'll stop there as well. But things to look out for is be able to substantiate what you say and also be able to sort of have a plan towards achieving the commitments that you say you want to achieve.
Sure. Yeah, I mean, on the PR front, I think we've all at this point seen, companies get lambasted on the internet for greenwashing. So definitely something to be aware of there. So we've talked about potential liability with, of course, the authorities, PR issues, but what about more sort of commercial disputes or even investment disputes? I'm going to ask Jack to come in to talk about this. He's a disputes lawyer, also got a lot of ESG experience. Can you tell us, some examples of cases relating to environmental issues and what are going to be looking at in the future?
Sure. Thanks, Michelle, and good afternoon, everybody. So there are literally thousands of climate change cases out there, actually, and one of the challenges that we have is how to categorize them. So we think one good way to think about them is to think of the claims in terms of how complex, difficult, and expensive they might be to bring. And human rights-based claims are actually some of the simpler ones to bring because often the causation and damages issues are fairly straightforward. And we may talk about those a little more later. But three of the most difficult cases to successfully bring, at least as we've seen so far, are claims against a corporate for failing to disclose climate-related risks, claims against a corporate for failure to mitigate their climate change risks, and claims against the corporate for climate change related damage. Now, the US case, New York v. ExxonMobil, provides an example of the first type of case, and it's set a bit of a model for Europe and elsewhere. This is a claim against Exxon alleging that it engaged in a fraudulent scheme to deceive investors regarding its management of the impact of climate change risks on its business. So it's similar to the greenwashing that Joseph was just talking about. And the Supreme Court of the state of New York dismissed the case, though, stating that the New York Attorney General had failed to prove that ExxonMobil had made any material misstatements or omissions about its practices. But the court also stated that nothing from its decision was intended, quote, to absolve ExxonMobil from responsibility for contributing to climate change. But ExxonMobil is in the business of producing energy, and this is a securities fraud case, not a climate change case. And that's the end of that quote. But so let's look at a climate change case. Specifically, we've got the now fairly infamous Royal Dutch Shell case in the Netherlands. And in this case, Shell was accused of failing to put in place sufficient policies to reduce its greenhouse gas emissions. The court held that the worldwide Shell group had an obligation to reduce emissions by 45% by the end of 2030 relative to its 2019 levels. And it reached this finding based on an unwritten duty of care in the Dutch Civil Code. The court then described this duty of care as an open norm that develops with time, depending on the factual changes in society and societal opinions. And applied to Shell, the court said that the duty of care derived from human rights and other soft law instruments, from the Paris Agreement, from scientific evidence on the dangers of climate change, and also the fact that Royal Dutch Shell's role as the top holding company of the Shell Group gave it responsibility for establishing the group's overall policy. And the court also pointed to the size of the Shell Group and Shell's individual responsibility to work towards climate change solution. But in the end, the court left it to Shell to decide how it would achieve this reduction, and actually said that the company was not yet in breach of any obligations. And right now, we expect Shell will be appealing that decision. Most of this climate change litigation is currently happening in the US, and there for the last 3 or 4 years, we've seen a spate of public nuisance claims brought by US state governments against fossil fuel companies, seeking damages to cover the costs that they are spending adapting to climate change issues. But one interesting claim against the corporation in respect of climate change related damage, which is pending before a European court, is the Liuya v. RWE case. And I will say that Freshfields is actually working on this with RWE to defend against the claim. Just to give you a quick summary of the key points in this case, which I find particularly interesting, the claimant, Mr. Liuya, is a Peruvian farmer who lives in the city of Juarez below the Peruvian Andes. And his claim is based on German law, specifically general provisions of private nuisance law, which entered into force more than 120 years ago, when of course no one was thinking about man-made climate change. And Mr. Liuya isn't seeking compensation for actual damage. In fact, his property hasn't been damaged at all, not yet. What he's concerned about is that this is going to happen in the future because there's a glacial lake above the city of Juarez. And his claim is that global warming has increased the risk of this lake flooding the city, including his property. And he claims that RWE's coal-fired plants in Germany, so again, we're talking about a farmer in Peru, suing an energy company in Germany for coal-fired plants in Germany that he says are contributing to the risk of this glacial lake flooding his property. And he wants RWE to pay its share of the costs to take protective measures against that flood risk. And his damages assessment is one of the things that makes this claim interesting. He's basing it on a report by a US geologist, Richard Head, which says that RWE is responsible for 0.47% of the emissions that are allegedly causing climate change. The report actually lists the percentage for all the big energy companies. And on that basis, Mr. Liuya is seeking damages from RWE in the amount of 17,000 euros. So it's a small amount.
Yeah.
But if the German court holds that this carbon report applies a valid methodology and that it's based on sufficiently robust data, this could cement the credibility of the report as a basis to estimate emission shares in other jurisdictions against other companies. So you would just look at their percentage listed in the court and sue them for that percentage of any damages. And so that's one of the concerns with this claim. And the claim's progressing right now. We expect it'll probably take a couple of years for a decision, but it's clear that the outcome, in particular, the court's willingness to rely on this HEAD report, will be of considerable relevance to climate change litigation worldwide, where that report might then be used again. And looking into the future, we expect to see further litigation against high emission industries by NGOs and even by individuals, perhaps bringing mass claims. Though at present, injunctions are more likely than actual monetary damages awards from these claims. But already we've seen the Shell case has led to copycats, including in Germany, where claims have been brought against automotive manufacturers and against other energy companies, including by NGOs such as Greenpeace, who've sent cease and desist letters in which they're requesting that these companies comply with specific measures to become CO2 neutral by 2050. And court actions have already been filed in September, October, and November of this year. So it's really starting to become quite active. Mm-hmm. And meanwhile, in New Zealand, in the case Smith v. Fonterra, the New Zealand Court of Appeal actually refused to recognize a common law duty to cease contributing to climate change. So refused to take the stand that the Dutch courts had taken. Instead, the New Zealand court said that this was too radical a response, and it was contrary to the common law tradition of incremental development. So in common law, we have a tradition that where the law is changing, it should do so in small steps. But I think in the years to come, if these kind of cases to continue, courts may find that this kind of response is no longer radical, and it might be more willing to accept these sort of claims.
Mm-hmm, mm-hmm. That's really fascinating. The cases, especially the German case involving the Peruvian farmer. If I could ask just a couple of follow-up questions on that one. So just to clarify, so the RWE, the defendant, did not actually doesn't have a plant in Peru. It's just based sheerly on the impact from Germany.
So this HEAD report studies the emissions of all these big energy companies, and then it actually has a table where it lists percentages of how much they're allegedly responsible for the emissions going into the atmosphere. And so based on that, and going to Germany, most likely because of this public nuisance law under German law that they felt was something that they could use as a hook to bring the claim, they're claiming that the coal plants in Germany, because they've done 0.47% of the emissions, then they're liable for 0.47% of the cost for the remedial measures in Peru.
Fascinating. I imagine if this case were to succeed in favor of the farmer, that's going to cause a lot of concern for companies worldwide who are involved in actions that are having very indirect impacts all over the world. So very fascinating.
And especially, I'd say, the ones who have larger percentages listed in this report.
Right. Definitely something to be aware of. Thank you, Jack. Thank you for that. Young-An, I think you've also dealt with a dispute involving an environmental issue and arising out of a merger and acquisition. I may have misstated that, but perhaps I could invite you to just share your experiences in this regard.
For sure. And before we do that, I really want to take a pause and thank you, Michelle, and IHCF, SIAC, and My for co-hosting this event. And obviously, all the attendees today, I owe you my gratitude as well. Before we actually delve into the minute nitty-gritty details of some of the disputes relating to ESG and the E of the ESG in particular, I wanted to kind of lay out the principle and the framework in which we in Korea have been asked to operate. In terms of human rights, other ESG areas, we've seen some of the guidelines from the UN and OECD. Now, recently, the Ministry of Trade and Industry in Korea has issued what's called KESG Guidelines, and basically indicates an encompassing list of about 61 categories or assessment issues where I think 17 of them pertain to environmental issues, and another 17% of the issues pertain to governmental or governance issues. Now, in terms of the environmental issues, as indicated already, we are able to see some of those emerging issues arising in the investor-state dispute public international law realm. But in terms of the commercial disputes or arbitrations, what I've been observing or handling pertain to an interesting interplay among various interdisciplinary areas encompassing insurance, M&A, corporate law. Recently, we've actually assisted a global entity dealing with waste treatment facilities. Now, they were all in view of the newly emerging ESG policies in Korea as well. And when the M&A transaction happened with respect to this entity, the sale and purchase agreement of its shares, issues arose as to the facilities and the competence of these facilities, the extent to which they were actually able to treat and refine the waste materials. What's called leachate and oil, waste, the technical terms are quite esoteric. And yet, in terms of the legal and commercial ramifications, common grounds arose pertaining to the representations and warranties provisions relating to violation of the environmental regulations in Korea, regulations pertaining to the non-contamination of real estate properties around the property and the assets, and then non-disclosure issues. Now, the ultimate outcome obviously created a dilemma where there was an inconsistency between the actual outcome of the facilities, the capacity of the facilities, and damages that might be owed as a result of the alleged breach of these reps and warranties pertaining to the ESG. Issues presented for resolution as after the fact was obviously interdisciplinary area pertaining to W&I indemnity policy provisions, how that policy provision might be constructed to the extent this alleged violation of the ESG could be covered under the policy, and under that policy, to whom would the policy payment obligations be owed. And as you may be well aware, these type of policies are utilized by sellers who want to have a clean exit. And in terms of the clean exit, they basically made it to the extent that the long-term rep and warranty period would not apply, and that they would not be able to file a subrogation claim against the party that they allege to be liable for this violation of this ESG. And so ultimately, what we've ascertained after dealing with this long, arduous claim was that it's quite critical to not be myopic about the ESG issues per se, but understand how they can interplay with multitude of corporate and interdisciplinary issues. And it was quite practical for us to understand that it's important to secure reasonable extent of insurance coverage and exclusion clauses, and understand how, even from the very get-go, underwriting call and Q&A session with the subscribers, particularization of the ESG concerns and how you want to expand or narrow the scope of coverage under the policy might be quite critical in the best interest of your client. Now, fraud or misrepresentation claims might be excluded from the viable claims under those policies. But again, it depends on the wording of the policies and how you interpret or construe or define these type of ESG related issues under the contract. And so it was an interesting exercise, and I think might be one that could be of interest to our clients when they deal with an ESG, but that's not entirely related to an E per se, but a number of other relevant areas, existing areas of law.
Thank you, Myung-An, for that. I think it's interesting to get the sort of private transaction perspective and where it comes in there. Unless anyone has any concluding thoughts on the E, we can go ahead and move on to social and governance. All right. So we've done, so ESG, environmental, social, and governance. We've done the E. Let's move on to social and governance. And I will ask Sharon to come in and tell us a little bit about what is encompassed under the term social and governance and what kinds of issues could arise there.
Thanks, Michelle. There is a growing awareness of ESG principles, and of course, much of the attention is on risk related to climate change currently, but social risks are equally important. The incorrect management of equality, business ethics, working conditions, etc., can have a great impact on a company's performance. So we see news of coerced labor is no longer acceptable to investors or customers, and the additional social costs will have to be borne by corporates looking to do business with the developed world. So we see investors who are now more discerning when it comes to putting their money in companies, and companies which are indifferent to social or the S or the G governance issues, are now shunned by investors and customers and stakeholders. And now with the social media and the cancel culture, it is much harder for companies to really hide behind closed doors and behind the boardroom. So what we see is that companies are now weighed down by ESG and reputational issues, and some of them even face share prices plunging due to mostly allegations of forced labor. In Malaysia, we saw a few examples of that arising out of from COVID, the global pandemic. And just last month, it was reported that Dyson Limited terminated its contracts and cut ties with the Malaysian supplier ATA IMS Berhad, following an audit of the Malaysian company's alleged forced labor practices and allegations by a whistleblower. It was reported that ATA shares plunged 30% after the announcement, and the company is expecting another drop of 40% for its financial year ending 31st March 2023. And according to ATA, Dyson accounts for almost 80% of its revenue. So we see the actual material financial impact arising out of a ESG issue, or in this case, a social component issue. The Securities Commission Malaysia also launched the Corporate Governance Strategic Priorities 2021-2023 last month to address the increasing demand for businesses to evolve beyond the traditional emphasis on shareholders and profit maximization towards greater consideration of wider stakeholders' interests. Essentially, the strategic priorities emphasizes the strengthening of board leadership by refreshing the skills profile and composition of the boards. So bringing in people who are able to contribute to policy making for ESG concerns, and to refresh the policies and practices of those companies to ensure that there is a right mix of directors to respond to the challenges and to anticipate future risks as well. Among these priorities include a mandatory 12-year limit on the tenure of independent directors in 2022, and the implementation of the requirement of boards of listed companies to have at least one woman director, and to accelerate progress towards achieving a 30% target in order to expand the existing talent pool with the inclusion of more qualified women. Apart from diversity in terms of gender, the strategic priorities also seek to deepen engagement with youths. So the young people from ground up, and this is done through collaborations with universities on new or enhanced Asian programs for the youth investors, as well as for directors of listed companies. Insofar as the governance component is concerned, the spotlight really is on executive pay, bribery and corruption, board independence, data protection, diversity and structure, and so on. A recent update to the legal and regulatory framework on this component in Malaysia is a corporate criminal liability offence pursuant to our Section 17A of the Malaysian Anti-Corruption Commission Act 2009 for corruption offences and for the personal liability of persons involved in the management of a commercial organisation. This offence came into force in May 2020, last year, and our stock exchange, Bursa, has also amended its listing requirements to encapsulate anti-corruption measures that took effect in June 2020. where listed issuers are required to ensure that policies and procedures on anti-corruption and whistleblowing are established and maintained for the listed issuer and its subsidiaries. There is an update also on this Anti-Corruption Commission Act, where the first charge and prosecution was made against a former director this year in March 2021, against a former director of a company for giving a bribe to the COO of another company as a reward to ensure that his company was awarded a subcontract from the oil and gas exploration production arm of the Petronas Group. So we have not seen any outcome to this yet. It is still in ongoing litigation. And essentially our Section 17A is modeled on the UK Bribery Act. And there is a deeming provision that if the company is found guilty, the senior management who is concerned in the management of the company at that time is deemed to have committed the offense unless they succeed in establishing the due diligence defense. So that's for the G. I wanted to also highlight mental health as it is now high on the agenda. And also again, I think exacerbated by the global pandemic. It was reported on Forbes that in the past year, more than 3,000 signatories to the Principles for Responsible Investment, PRI, indicated mental health as one of the top social issues they would prioritize, and some have even called for moving to ESG to incorporate health alongside the movement to add the chief public health officers in the C-suite. So perhaps we'll be looking towards ES with an additional H and then G. So we see companies now contributing to creation of products and services with high positive impact on mental health. Companies are now standing for their commitment to work-life balance, employees' benefits and well-being, positive employee reviews for the experience at the company. So, and this we see not only in corporates, but also across the boards. You know, we see that even in firms, in any company, any sort of workplace environment. So that is a really that is really something that we are looking forward to in the future. Perhaps to have it as ESG instead of ESG.
Thanks, Sharon. Really insightful discussion there. It's nice to see so many progressive developments, particularly in the area of social, and then talking about mental health. You know, just looking at my news feeds, you know, you really do start to see a lot of these issues much more at the forefront than they may have been 10, 15 years ago. So all very interesting and positive developments in my view. But of course, with you know, with opportunities, there's also some risk. And I know Jack had earlier mentioned a dispute involving human rights, and maybe you could tell us more about that, and generally about what kinds of disputes you could see arising out of the social or governance aspects of ESG.
Yeah, so one thing I actually wanted to take a minute to talk about, Sharon mentioned this, but it's a very important aspect of human rights disputes, is this risk that it can cause to your corporate reputation. Of course, companies spend a lot of time, effort, and money building up their reputation. And we're seeing the human rights violations, and in fact, of course, just allegations of human rights violations are doing a good deal of damage to reputations and undermining a company's profitability. And this can be caused by press reports, by boycotts, and of course, Sharon mentioned the cancel culture, and eventually by litigation. But one thing I just wanted to stress that you want to bear in mind is that this risk doesn't arise only from your own company's behavior. For example, we have advised a client here in Asia who's in a joint venture with another company, and that other company has been accused of human rights violations related to its palm oil business. And in that case, our client was not involved in its joint venture partner's business activities that gave rise to these allegations. But of course, it recognized that just being in business with a partner that had those kind of allegations brought against it could now harm its own reputation, even if the allegations were not against it. And in that case, our client took a proactive measure and exited the joint venture to avoid harm to its own corporate reputation. But of course, you and your company may not always have the right to make such an exit, or at least not to do so easily or without having to pay a cost. So it's important to give some thought to your joint venture agreements and whether they provide sufficient protection for your interests should your joint venture partner be accused of or indeed guilty of human rights violations. Of course, we're seeing things like this with claims about supply chains, again, as with forced labor issues, as Sharon mentioned, and some courts are starting to look at climate change as a human rights issue as well. So there's an overlap there between environment and social issues. But for your joint ventures, what you want to make sure is you've got the ability to terminate the agreement in a way that's commercially reasonable for you if these kind of concerns come up. And further, something that companies often overlook, these agreements, of course, always have a confidentiality provision. And what you want to make sure is that you've got an exception to those confidentiality obligations that allow you to provide public comment on alleged human rights violations against your joint venture partner if you think it becomes necessary to do so. That's just one thing to bear in mind with this type of litigation, so that you can hopefully use that to avoid some reputational harm to yourself. And of course, from the start, and I'll come on to talk about this a little bit at the end, but it's important to be aware of your partner's activities and to choose those partners wisely.
Yeah, yeah, that's very interesting and very practical advice. I imagine that would apply for environmental or climate change issues as well. You don't want to be a company that's associated too closely with another company that's being accused of climate change violations and like greenwashing and so forth. Thank you for that, Jack. We're going to change directions a little bit in a minute, but I just wanted to see if anybody else has any comments that they wanted to add on the G, the social, and the governance, or even going back to the environmental before we talk a little bit about technology. No? All right. Okay, then let's move on. Let's change gears a little bit and talk about disputes relating to new technologies, which in many cases is actually related to the governance issues as well. So Myung-an, can I invite you to share your experiences and observations in this area?
For sure, thank you. One of the areas that I wanted to kind of touch upon today is the issue of cyber attacks and how that has been dealt with in dispute resolution realms, as well as in general practice for our corporate clients as well. I mean, what do we talk about? I mean, what are we referring to when we say cyber attack? And when I looked into the definition, there was a reasonable definition of the event issued by the Institute of Risk Management in the US, and it basically indicates that it refers to any risk that is related to financial loss, disruption, or damage to the reputation of an organization from some sort of failure in the IT system. And quite a broad definition, and one that can entail a number of legal and commercial ramifications for sure. In the context of disputes, I mean, we've dealt with, it's a general description of the dispute could be twofold. One that deals with a commercial technology related dispute between the supplier of the cybersecurity mechanism and the recipient of the same, and how the obligations under that security mechanism were or were not fully fulfilled. In that type of situation, obviously, investigators' role and technical staff and experts' insights into what exactly happened and how the simultaneous evidence of what happened are well preserved. That could be critical, and some of the fact-intensive exercise that we have done in that type of situations related to preservation of, or ascertaining of the market standards, protection of activation logs that are quite standard in the market, configuration files, the traffic packets, foreign logs, as well as the quantum of the loss. Obviously, there will be allegation of consequential loss in that type of cyber attack situation, and the reasonable realm or limitation you can put, or depending on which side you represent, the reasonable extent to which you can further pursue your recovery from the counterparty could be quite helpful. And so in that type of situation, once again, technology related investigation and very quick and prompt and swift response in terms of the document preservation and evidence files could be helpful. Now, the other prong of this analysis pertaining to cyber attack relates to the legal delineation and the jurisdictional differences as to how that can be defined and whether or not the cyber attack in itself, once determined as cyber attack, could be protected as, say, force majeure or under the force majeure clause. So I looked into the precedents in civil jurisdictions as well as the common jurisdictions, and by way of example, Korea is obviously a civil jurisdictional area, and whilst I don't represent to have an exhaustive case law file on the case precedents on that issue, absent any specific wording in Korea, a contractual liability arises to the extent a default occurs due to a negligence or wrongdoing misconduct of the defaulting party. So obviously under that civil code, it's reasonable negligence, tortious liability type of review that will be applied when you determine whether or not the cyber attack in itself could be protected as some kind of uncontrollable force majeure event or something that's above and beyond that. So by way of example, force majeure during the, I don't know whether some of you might be young enough to remember IMF crisis. I am slightly older, so I can remember what happened in 1999 or 1998. And during the era, there were a number of claims. I mean, we're now dealing with COVID-19, but at the time they were talking about force majeure in terms of this IMF crisis. And even in certain such as extreme situations, the courts in Korea basically did not uphold a wider definition of force majeure, and saw that an element of foreseeability would be quite critical, even if you were dealing with extraneous financial crisis. And so number of cases that actually upheld foreseeability or force majeure clause in that type of situation during the era is quite limited. Now, in common law jurisdiction, as you may be well aware, a generalized doctrine of force majeure, it's not existent. So you'd obviously depend heavily on the actual construction of the wording pertaining to the cyber attacks or any kind of events that you didn't expect in advance. And burden of proof obviously would lie with the claimant and one that's claiming the force majeure. One practical observation we could make in that context is that oftentimes people refer to a sweeping clause and how that is related to the categorization of the events that had been mentioned before, the principle that is called ejusdem generis. And basically, once you actually have a sweeping clause and try to cover most of the uncontrollable events, that also be subject to limitation to the extent that those events would have to be akin to the event or specific matters that have been mentioned within the same clause or provision within the contract. That can be tailored by practice. You can indicate that cyber attacks, if you fail to indicate that cyber attack in itself was a specific force majeure event, and even if you are facing a jurisdiction where this type of ejusdem generis type of principle would apply, you can tailor it to the extent that that type of sweeping or limiting clause would be inapplicable, and you could say that it doesn't become limited subject to limitation clause per se. And so, long story short, prior to dispute pertaining to this cyber attack, you might want to look into the exact wording of the catch-all phrase, whether or not that's all-encompassing, whether you can actually tailor it to the extent that you can protect your client's own interests. If you cannot really allocate risks adequately with that type of provision per se, you can anticipate, and if you can anticipate this type of a cyber attack, you can include an exclusion clause or limitation of liability clause, something that would be akin to the interests of your own clients. Post dispute, obviously, you'd have to deal with mitigation of damages and impact, fact-intensive investigation as to which party was more or less liable for that type of event, whether or not there were adequate security measures in place. And there are various mechanisms you can actually put in place in order to prevent or secure against that type of attack. And so I'll end here, but there are some of the recent observations that I have made in the context of cyber attacks and legal liability.
Yeah, thanks, Ming-An. Yeah, cyber attacks, very, very scary stuff. And with so much of our lives online now, some of which our work online, it's certainly something we need to be aware of and cautious of. Another tech-related issue that we'll be talking about comes out of Malaysia and their recent attempt to roll out 5G. So if I could ask Sharon to share her perspectives on this interesting situation in Malaysia.
Sure, thanks, Michelle. One of the emerging areas of dispute that I see in Malaysia is technology issues relating to the implementation of the 5G rollout. The government has announced that 5G will be implemented starting from the 1st of January 2022 in a few weeks' time. And really, I think depending on the manner in which 5G implementation is carried out, there may be disputes arising in relation to potential disruptions to the existing service providers who are occupying the same spectrum or the frequency band that 5G services will be sitting on. And I think in most jurisdictions in the world, the preferred frequency band is the C band, between 3.4 to 3.8 gigahertz. And in Malaysia, I have seen some issues where service providers, for instance, satellite service providers who are currently sitting on the same band have been, are having issues or disputes that that their services would be disrupted once implementation of 5G is rolled out in January. And we are seeing cases where they have taken disputes against the regulators on these matters. I'm currently working on a case where I act for a satellite service provider which has a dispute with the regulator on the manner in which 5G implementation is being rolled out in Malaysia. I foresee a potential increase in disputes up and down the chain relating to these issues, whether it's compensation or time required to sort of migrate to a different frequency band and so on. So this may there'll be more disputes coming out, I think, in the year to come.
Yeah, that's very interesting to hear, and very Malaysia specific, but sort of interesting to watch as that develops. So we've got a few minutes left, and I would invite the audience to pose any questions that you have, and we'll try to get through some of them. But in the meantime, we wanted to end this webinar with some very practical advice for companies about how to think about risk. So if I could get Jack to explain it, talk a little bit about heat mapping with respect to ESG and how that can help companies.
Sure, thanks. And so Sharon mentioned that we're expecting more disputes, and of course that's true really globally. And we've talked a lot this afternoon about ESG risks that companies are facing. So what do you do about these risks? And one approach is what we call heat mapping. Conducting an ESG risk assessment usually involves a two-stage heat mapping assessment of your business operations and your suppliers that focuses in particular on operations or suppliers that represent a human rights risk. So this is identifying the heat, as it were, in your business. That companies might have a higher risk due to their location, to the industry, or because of opaque supply chains. And this process involves first conducting a gap analysis and review at a very high level of your existing policies and your procedures and information in relation to your own operations and also in relation to your suppliers, for example, through conducting supplier audits. And also a desktop research to heat map potential human rights impacts in your own operations to identify these risk areas. And you can do this through press reports, through commentary produced by governments and NGOs. And this exercise should be undertaken before moving on to any more systematic or detailed due diligence focused on potential human rights risks identified in the course of this first level heat mapping exercise. Some questions as senior management will want to ask to ensure that this initial heat mapping is fit for purpose include, is the risk assessment tailored and comprehensive? Human rights risks are most effective, assessments are most effective when they're tailored to a company's particular business strategy, risk profile, and culture. It's not really one size fits all. You need one that's bespoke for your business. And you also want to ask, does it look at all potential human rights impacts of the company's operations, and again, of your supply chain, or whether there's some blind spots and things you might miss. You should consider if all the relevant areas within your organization are involved. Ultimately, management for these things, management has to be clear on who within the organizational structure owns each risk, and should ensure that the ESG risks do not remain siloed with just your sustainability team, because you want to involve a wide range of functions, because it helps you identify what the risks actually are and then deal with them. And you also need to understand your company leverage and the tools that you have to exercise leverage over your suppliers. So where you as a buyer have more purchasing power, implementing robust due diligence strategies from the start of the business relationship can increase transparency, improve supplier conduct, and of course, protect you. Where you have less purchasing power, you might be able to exercise leverage through other actors, such as governments or NGOs who can put pressure on your partners. And finally, once you've completed this heat mapping, this first level exercise, you need to make sure you implement a mitigation strategy. You need to address all the relevant human rights risks that are identified by this assessment, but you can prioritize them. So you can address the ongoing infringements of human rights if you identify any as soon as possible. And you can also prioritize other risks based on their severity or how easy it would be to remediate them, so that you know how to prioritize your resources. And this involves developing a detailed response plan. So you should use the heat map that you've prepared to identify the areas that you need to address, and then work on a plan on how to address them.
Yeah. Thanks, Jack. That's very practical, very useful advice for folks. So we've talked a lot about risk and disputes, and I just wanted to end with something a little bit more positive. So let's talk a little bit in the last few minutes about opportunities. So yes, ESG does come with regulatory risks and potential for disputes, but it also brings opportunities. And if I could get Joseph to talk about some of the opportunities we could be looking at in the coming years.
Thanks, Michelle. So in our firm, we actually work a lot with the banks, and one of the sort of big opportunities that is rising from all this attention to ESG is actually green financing, as well as social financing or sustainability financing. And there have been a lot of new products for banks to have created, like green loans, green bonds, social loans, social bonds, and so on. And these are slowly sort of the standards for all these products are starting to coalesce because of industry-driven definitions. In Singapore, the Monetary Authority of Singapore is also coming up with incentives to encourage borrowers and issuers to take up these financing opportunities. They typically come with attractive financing costs to encourage borrowers and issuers to invest in green activities or to improve on their green performance. And then as a result of meeting certain sort of targets, performance targets, then you are entitled to certain financing sort of incentives. The other sort of big opportunity that I see happening is the carbon markets. And because of the awareness of the need, according to IPCC report and Paris Agreement, the need to be net zero in emissions for the whole world as a whole, to have net zero emissions by 2050. Many companies, investors are now looking at ways to reduce emissions, but also invest in solutions that will lead to either capturing more emissions or reducing emissions elsewhere, and therefore benefiting from the credits or from the negative emissions, if you like, that result from these projects. So in Singapore, Singapore has aspirations to be a carbon trading hub, and we recently our sovereign wealth investor Temasek, together with SGX, together with DBS, our Singapore bank, together with Stanchart, have invested in a exchange called Carbon Impact Exchange. It looks to encourage investment in what we call nature-based climate solutions in the region, because we have a very rich biodiverse region, and the Climate Impact Exchange looks to encourage investors to invest in biodiversity-related sort of projects that will improve, for example, reforestation, that will protect forests, lead to greater absorption of CO2, in process gain carbon credits, which can be sold off in an exchange to offset the emissions made by other sort of emitting industries or emitting businesses. So carbon trading looks like it's going to be a big business. It's not necessarily a bad thing, because if it leads to overall fewer net emissions and it leads to greater biodiversity, then we'll be trying to solve two problems at once, which is addressing the global climate change problem, but also addressing the biodiversity loss crisis. So this is an example of market forces, opportunities arising from market forces, and opportunities for investors as well as for banks.
Great, thanks, Joseph. It's really heartening to see that these types of new initiatives that maybe were considered very radical 10 years ago are actually being funded and are being sought out by big banks. And so it's just great to see these kinds of funding opportunities, and we look forward to seeing what kind of developments emerge from them. So that does bring our webinar to a close. I will say thank you to all of our attendees for joining us this afternoon. Thank you so much to our speakers for that very interesting and lively discussion. I wish everybody a very happy New Year, Merry Christmas. The end of the year is upon us. And we look forward to seeing you all at SIAC events and courses and seminars and so forth in the new year. Thank you, everybody.
Thanks, Michelle. Thanks, everyone.
Thanks very much.
Bye-bye.
Thank you.
Happy New Year.